Sure, disorderly conduct and loitering and prowling.
Thank you. Usted está aquí por conducta inadecuada o alteración a la paz y andar lo que sería merodeando.
The state's offer for both is a conviction, $1,000 fine, and 60 days jail.
We told Judge that you would be asking to represent yourself again today. He is good to go with the FREDA inquiry and all the
I have a problem with the FREDA inquiry being a Fifth Amendment violation to use against me. There should have never been a FREDA hearing because the challenge to jurisdiction was never established.
Okay.
And so even with proceeding forward is not appropriate.
Okay, so that's what my supervisor is coming in for, just to handle that, because I don't want you to feel like anything is happening, on our end. So he can address that with you. The only way to proceed, and in our courtroom, I don't know, how it goes in other places, is the FREDA hearing. Basically, the idea is that they want to make sure that you are able to represent yourself competently. I've had many conversations with you. The motions you've written are very well written. I know that you can do that.
I don't like the trick questions, the yes, the no. They're not really clear. They're very ambiguous to me.
Mm-hmm.
So I dislike that whole thing.
I know. And unfortunately, there's nothing, that is what was given to us by the law. That is between you and the judge. That's not something any of us can handle. The only way that we can be removed through that process by asking to represent yourself is through the FREDA questions. That was from the case in FREDA. That is the questions to make sure that you're doing this of your own free will, that no one's trying to make you do this, anything like that.
Right. And that part I get. The problem I have is the challenge to jurisdiction has never been established, and so therefore he jumped ahead to a FREDA hearing, which violates the actual due process that once it is challenged, you cannot proceed forward. So why hasn't the challenge to jurisdiction been established? Because the state has not responded to any of it, and they're the ones that have the burden of proof to prove that.
So I can have my supervisor come out and talk to you about that, just because that's not something that we do every day. And I know that maybe we should, but unfortunately it's not something that we do every day. So that's why I'm going to have him here to make sure that you understand all of that and what remedies there could be for that, if any.
Okay.
And then in the meantime, the other thing, and this is one of those things that technically the public defenders are not allowed to represent anyone who is not indigent. I don't know your financial status. I do not believe you are indigent. Usually I think the threshold for that is about $25,000 a year. That is something that my supervisor is going to come talk to you about. Basically, even if I was to conflict off your case and I have not been given approval to do so, anything, sometimes when there are accusations made, like disagreements between us, basically like me not filing, you wanting me to file, things like that can rise to a conflict. The issue is it hasn't gotten to the level where it is appropriate for my office to conflict yet. And the other issue, which would be the most concerning for you, is that even if I conflict off, a different attorney is just appointed to you. And obviously that puts you back in the exact same position where you don't want to be.
Okay.
So that's part of the reason that we haven't done the conflict yet, because it doesn't accomplish anything and it just stalls this out longer for you before you can have anything heard. So
Obstruction of due process. Yeah.
So one of the things that we can try is going to be raising the indigency thing. Basically, that would take us off. How this happens is in a standard situation, you are either asked, can you afford an attorney? If you cannot afford one will be pointed to you. If you are found to not be indigent or not qualify for the public defender's office, you basically get a reset to go find a private attorney. Obviously, you want to represent yourself. So I think...
Because I never waived my right to counsel. You have the right to an attorney or to counsel.
Okay.
And counsel does not mean it has to be an attorney.
Okay.
Yeah.
Understood. I think, and this is usually the case, why he did it was because he felt at the time that he could not have that conversation with you. And I have had many conversations with you. I know that you're capable of representing yourself. I have no doubts about that. Unfortunately, it's an awkward position where it feels like it's you versus me, but I promise you it's not. I am not.
Well, unfortunately, what I see is the conflict of interest, because every single person that is involved in this situation is actually paid by the state. And the state is a public office, correct? And so therefore there is a conflict of interest because the same body of men that are actually trying the case cannot be involved in the case. So that in itself is automatic disqualification of the judge as well. And the fact of the matter is that public office equals public trust, which means as one of the people, I am the public, and that I'm one of the people that is a beneficiary. And so therefore, the judge has a dual responsibility to act in my best interest and not to turn around and obstruct due process. And the fact of the matter is that when he jumped over to the Feretta and assigned me public defender, he was not addressing the jurisdictional challenge. And that in itself is, anything after that is void, technically.
So then in the meantime, because that's again not something that we address every day, that's why a supervisor is coming down to do that part of that. But just so that you have all the information and that if you are able to represent yourself today, that I give this to you ahead of time. I think we had talked about it briefly last time where in a normal proceeding, if we get this far, the choices are to either resolve your case by accepting a plea agreement, something of that nature, or to set for trial. Those are really the only two avenues. This is what is called a pretrial intervention application. I have a very strong feeling you have no interest in it, but again, I have to let you know. And you know, there are benefits to it. I think we talked last time, this is something that if you applied with the state, they would dismiss your cases at the end after you did community service hours or whatever they see fit. Again, I know that that is not something that interests you in the slightest, but it is something that I'm by law required to let you know, any offers or anything like that.
I'm just disappointed that the public defender is forging, not public defender, I'm sorry, the prosecutor is forging ahead despite the evidence that is there that he clearly has not watched. And so to me, that's malicious prosecution, and that's unfortunate because that's that right there. The idea that you're trying to get me to plea, not you specifically,
no, I understand.
is actually like, that's malicious prosecution.
I understand. And obviously this is not something that we deal with every day, so like it is new to a lot of us, and that's why I'm seeing to it that a supervisor who's been doing this for 35 years is here to make sure that everything goes smoothly, that I'm not missing something the states. Yes.
Okay.
So he will be here in a little bit, and Judge, like we said, he will go over the Feretta questions. I understand that it's not maybe how it should be done. I'm not really able or willing to discuss the morality of that at the moment. Basically, the only way to represent yourself is to get through those questions, and unfortunately it's not going to be something where he says, because I know last time one of the things was you were very clear that you comprehended what he was saying, but that you did not, I believe you said stand under it.
The word understand is very tricky because it's standing under authority, and I'm not granting jurisdiction.
Okay. And if it helps, you are able to say yes and no, but again, he's asking if you understand.
That's still understand.
Understood.
Yeah.
So then basically, if we are unable to get through the Feretta hearings, if those are not questions that you want to answer, the two options, and I have run this both by judge to make sure that these are my only options and by all of the supervisors in my office, are we either ask for another reset or we set it for trial. And I understand that these are nothing that you want to do.
You mean another pretrial?
Yes, ma'am. And unfortunately, in the meantime, I would still be on your case, so we wouldn't be getting anywhere with that. So it's kind of just kicking the ball down the road, as you know. So do you have any other questions for me other than the obvious?
Is there a list of the questions for the Feretta hearing that I can review?
That
would be helpful.
I don't have them. We've never printed them out.
That would be really helpful because I don't like the on-the-fly stuff.
Okay. Yeah. Let me see what I can do. It may not be something I can print out in time, but if I can give you my laptop and have you review it.
I do have another question for
ma'am.
you. Do you happen to know how many documents are on the actual record? Because when I went down to the county clerk to ask for certified copies, she threw out some number that made no sense to me. So if you could find out how
high
many,
or low?
it was pretty damn high. I was like,
pretty high? Okay.
I'm like, that doesn't make any sense to me.
Unless, is it possible she was going by pages? Because I know some...
Yeah, it's pages.
Okay.
But my question is because clearly they're not all on the public record. So
yes, ma'am.
Accessing that, how do I get all of that?
Okay, I'll look into that too.
Okay.
I think that should be... I may have to ask Madam Clerk while you're up there, but I will get the answer to that as
Thank
well.
you.
And so what you're really seeking, you just want like a copy of all of it? You just want to be able to see it, or?
Yeah,
Okay.
that as well, because I need to know what is actually filed that I don't see, because even the Ferretta hearing doesn't have anything in writing. So like there's discrepancies, like the paperwork I filed Friday that I sent you copies of.
Yes, ma'am.
There's an issue with the clerk. This is like the third time it's actually more than 3 times.
Understood.
I
We deal with them
filed-
every day too, so we get it.
It's not good because the clerk is the record keeper, and when things are not right, that goes back on the clerk. I filed those papers specifically for all of the case and the citations, and there's nothing on that docket.
Okay, and that may be, and I think we had talked about this before, maybe briefly. When you have an attorney represented or appointed to you, the court cannot hear it. I do not know if it means that they're
It's
not.
still a record, though.
That's what it
still
should be.
on the record.
Absolutely, because
They
we
weren't
have access to
motions or
that.
anything. They
Yeah.
were affidavits and notices.
Yes,
so,
ma'am.
Yeah.
Okay. I will look into that, and I will see if I can get you a copy of the Ferretta questions.
Thank you.
Mhm.
Feels better in here than in there.
Okay. Hello again. Mr. Williams is here with me.
Hi there.
Nice to
How you
meet you.
doing?
Again, yes. So I have asked Judge to provide us with a copy, and unfortunately, he's not giving us a copy beforehand, and there is nothing published officially online for me to show you with the Ferretta questions. As for the jurisdiction issue, the issues and the other motions, we have reviewed it, several of us, and we do not feel that there are any motions for jurisdiction or anything like that at this time. I understand that you feel differently. If those are motions that you want addressed, we either have to get through the Ferretta hearing.
How many questions is it?
Friday hearing?
I think it's in the ballpark of 10 to 15.
Yeah. I mean, I think they'll be the same ones he started with last time. I'm not sure when he stopped, if he got to the end or.
I
It
think
was
we got
long.
fairly close.
It was extremely long, which is why I wanted to read it first, because it's extremely confusing, very ambiguous, and I don't like the word understand.
And we get that. So either
Well, you can answer the question without saying the word understand. You can say, Judge, I comprehend what
I
you're-"
did, and he was giving me a hard time last time.
I think he had a problem with the second part to that, not the I comprehend, but the but I do not stand under that.
So the only thing I wanted to add is just that so when we get appointed to represent you, we are appointed to represent indigent people, and we are appointed to ensure, we are appointed to represent them. There's a slight difference between, so when you ask for a motion, we have to decide whether we feel it's an appropriate motion. If we do, we file it. If we don't file it. If you hire a lawyer, there's a slightly different mindset, process, however, because you're telling them, hey, look, I have hired you to argue this motion. I have hired you to raise this issue. And now, I'm not suggesting you have to go out and hire one, but that's a different, it's like you have a contractual relationship with that person. So, I mean, that's, if there are motions that you feel strongly about and you have the resources, and I have no idea whether you do or not, you may get answers to those, you may see those motions and you may get answers to those questions in that way that you would not get from the public defender's office.
I got that. So one of my concerns, though, is also that I have the right to a lawyer or attorney, and I have the right to counsel as well. So I could have someone as standing counsel. I've never waived that. There's nothing saying you have to have a lawyer, a license or bar association.
Are you referring to yourself or to hiring another person?
No, I'm talking about the requirement of hiring someone. I should have the right to counsel as well, not just I have to hire somebody who's got a license. That's something I sent in the paperwork that I emailed. And that's where I feel like that's being left out. So if I wanted to have someone serve as counsel for me, I should not be, it should not be like taken from me. I never waived that right. I've never waived any rights.
Okay, I'm not sure I understand, but
There's nothing saying, my point is there's nothing saying that someone has to have a license to practice law, to be a counsel or represent, or to not represent me, but to work
right,
with me.
I mean, I think what the process says is that you have the right to an attorney. You don't have to have an attorney.
Right. Or counsel. It says or counsel.
Right, I agree with that. I mean,
Counsel doesn't mean you have a license, is my
there
point.
may be a difference of opinion with the judiciary or of the definition of counsel, but the premise is correct in that you have the right to an attorney. You are not forced to have an attorney.
Mm-hmm. I think it's in the Fifth Amendment. Yeah, it's the Sixth Amendment. And to have assistance of counsel for his defense.
Sure, I don't disagree with that.
Yeah.
I'm not sure whether the appellate courts or any other courts have ruled on what is the definition of counsel, whether if someone is not a lawyer, do they fall under that?
Now that's the
Don't
supreme
know.
law of the land. I'm not even going there with that. Like that's just the right to counsel. Whether it's defined a certain way, well, that's actually up to the people, because the power is not enumerated in the state and such. It belongs to the people as well. That's the part that is
Okay.
clear. So I mean, if something's ambiguous, then it should be interpreted in favor of the individual.
Then you're certainly able to raise that issue if you are given that option.
So then for today, I think we're gonna do the FREDA hearing again. If you're
Okay.
able to get through that, then perfect, you get to represent yourself, you get to do all these motions. And if not, like I mentioned earlier, basically he's gonna look to me and he's gonna say, set it for trial or reset. And obviously, we've talked before briefly about you not having a desire to go to trial, at least at this time. So if that situation happens, I would be asking for a reset, okay?
Okay.
Is there a day of the week that you would prefer? We do Tuesday, Wednesday, and Friday mornings, or Monday afternoons.
Monday afternoon's fine.
Okay. Then,
Did they require that you fill out a affidavit or application for the public defender's office, or what's called an affidavit of indigency?
Mm-mm.
Were you appointed the public defender's office at a appearance when you were in jail?
No.
it was arraignment.
No, it was the forcing of it. It wasn't even It wasn't
So at the
consensual.
arraignment, and they did not make you go down and fill out the application, which is weird, because they just did it to someone else in there and said, no, you make too much money, you have too many resources, so I will not give you the public defender. I'm not sure why he's not requiring that in your case, but that's not I don't enforce their rules, so if they're not imposing something on you that they impose on others, I don't ask that it be imposed on you. As I said, it is a way to get us off the case. If you were found to be not indigent, then the public defender's office cannot represent you.
Mm.
I'm not suggesting you do that. I'm just saying to you how it is that I don't understand how it was that wasn't asked of you at the arraignment. It was almost like, it sounds like they forced you to take us as opposed to you asking for us.
That is what happened, actually.
Okay.
Neither one of you were present for it, so
Mm-mm.
yeah. Okay.
Okay,
So
well,
then-
I'll be here.
And we'll get through this.
Again, I'm not waiving rights. That's all that matters to me right now.
Okay, who's next? Come on up.
I'm here retaining all of my creator endowed rights, and I waive none. My presence not to be considered consent to jurisdiction. I come in peace as a non-combatant. I'm here for the matter of Labonte Lana Ann, and I'm sui juris, not pro se, a woman of the people. Special visit appearance under threat of arrest and protest, only reserving
and not waiving any of my rights, not submitting to the jurisdiction only solely to challenge jurisdiction.
Okay. So we're here on the driving license suspended revoked and resisting arrest without violence. What's going on, Ms. Trey?
Yes, Your Honor. She would like the opportunity to go through the FREDA hearings and represent herself at this time.
Okay, Ms. Levante, is that correct?
Yes, I'd like to present myself only.
Okay, so I'm going to go through for an inquiry. We've tried this twice, so we're going to try it a third time. And make sure to respond to the questions that I have when you came in after this. Please raise your right hand for me.
Who am I swearing to?
You're swearing to tell the truth, the whole truth, nothing but the truth.
I affirm my
Affirming.
yes. I affirm my yes is my yes and my no is my no.
Raise your right hand.
Could I see the Bible? Because my God's not your God.
Maybe he is, maybe he's not. I don't have a Bible up here. We're not swearing a Bible. Raise your right hand. If you're not swearing under oath, I'm the one who's going to be placing you under oath. And if you did not do that, then there's no way we're even getting close to a FREDA. So.
Can you
raise
show
your right
me
hand
what
now.
I'm swearing to? I need to be fully informed.
What I'm going to ask you to swear or affirm is that you.
I affirm that my yes
hold
is
on.
my yes and my no is my
Ask me a
no.
question, you can answer.
Sorry.
You asked what I'm going to have you swear to do or affirm, which is that I'm going to ask you, with your right hand raised, whether or not you swear or affirm that everything you're about to say is the truth, whole truth, nothing but the truth. So you can either raise your right hand to do that, which is how we do a swearing in, or you cannot. If you don't, then you're not sworn in and you can't go forward.
I do affirm that
Okay, so raise your right hand.
I affirm
Do you
to
swear or affirm everything you're about to say to be the truth, whole truth, nothing but the truth?
I affirm that everything I say is my truth.
Okay, fair. Well, not your truth, the truth. Do you swear from everything you're about to say will be the truth, whole truth, nothing but the truth? Yes or no?
To my best of my ability, yes.
Yes or no?
Yes.
Okay, thank you. Put your hand down. So you said you wish to represent yourself. Let's go through a FREDA inquiry. You are currently appointed the Office of Public Defender. Do you understand that you have the right to have a lawyer appointed to represent you if you cannot afford one? Do you understand that?
I comprehend.
Okay. The state of Florida will pay for a lawyer to advise you in these court proceedings. Do you comprehend that?
I comprehend.
Shall I appoint a lawyer, or shall I have the Office of Public Defender continue to represent you in this case, yes or no?
No.
I would like to explain to you some of the ways that having a lawyer to represent you can be to your advantage. During the pretrial phase, a lawyer's legal knowledge and experience may favorably affect bail or pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. At a trial, a lawyer has the experience and knowledge of the entire trial process. He or she will argue for your side during the whole trial and present the best legal argument for your defense. Since jury qualifications and selection are governed by numerous legal procedures, a lawyer's knowledge and experience may enhance the selection process on your behalf. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, the consequences of that decision, and what you have a right not to say. A lawyer has studied the rules of evidence and knows what evidence can or cannot come into your trial. A lawyer may provide assistance in ensuring that the jury is given complete and accurate jury instructions by the court, may make effective closing arguments on your behalf, and may prevent improper argument by the prosecutor. A lawyer may ensure that any errors committed during trial are properly preserved for appellate review later by a higher court. At a post-trial phase, if it gets to that point, if you are convicted, a lawyer's assistance may be useful in preparing for sentencing, ensuring that favorable facts are brought to the attention of the court, ensuring that the court is advised of all legally available favorable dispositions, and ensuring that the sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking release on bail pending the appeal. Do you comprehend all that?
I comprehend.
As it is almost always unwise to represent yourself in court, let me tell you a few of the disadvantages of representing yourself in court. Do you understand that you will not get any special treatment from the court just because you are representing yourself?
I comprehend.
Do you understand that you will not be entitled to a continuance simply because you wish to represent yourself?
I comprehend.
You are not required to possess the legal knowledge or skills of an attorney in order to represent yourself. However, you will be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to learn and abide by. If you demonstrated unwillingness to abide by these rules, I may terminate your self-representation. Do you understand that?
Comprehend.
Well,
I comprehend.
I understand what you're saying, but I need you to acknowledge that statement and agree to that?
I acknowledge that statement.
And you agree to abide by the rules of criminal procedure, the rules
Yes.
of criminal procedure? Okay. Do you understand that if you are disruptive in the courtroom, that the court can terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence?
I acknowledge that.
Okay. Do you understand that your access to the state attorney who is prosecuting you will be severely reduced as compared to a lawyer who could easily contact the state attorney?
Say that again?
Do you understand that your access to the state attorney and assistant state attorney who is prosecuting you will be severely reduced as compared to a lawyer who could easily contact the state attorney?
I comprehend.
In addition, the state will not go easier on you or give you any special treatment because you are representing yourself. The state will present itself against you as an experienced lawyer. Do you understand that?
I comprehend, yes.
And finally, if you are convicted, you cannot claim on appeal that your own lack of legal knowledge or skill constitutes a basis for a new trial. In other words, you cannot claim that you received ineffective of counsel. Do you understand that?
I comprehend.
Do you understand these dangers and disadvantages of representing yourself?
I comprehend.
Well, do you understand them, yes or no?
I acknowledge it.
Okay. Do you have any questions about these dangers and disadvantages?
Not at this time.
Have you received and read a copy of the charges against you?
No, not fully.
Do you understand all the charges against you?
No.
During the time that you've been represented by counsel in this case, did you discuss this case with them,
Not in full detail.
the public defender's office? Do you wish to have more time to speak about your case in more detail with the Office of Public Defender before moving forward with this for an inquiry? That's your decision. Which means, if you want more time to discuss with Ms. Trey and Mr. Williams, and the charges in this case, and anything about procedure about this case or anything along those lines, before moving forward with the Ferretta inquiry, I will give you that time. Do you need more time to do that or no?
Would this end the phoretic inquiry?
Depends how
Or?
much time you need.
Okay.
I mean, I'll give you a couple minutes to chat in the side there if you want more time.
The only question I have is I have not fully received all the documents that we discussed.
What I have given you the discovery that we have and
Right,
the
but
body cam.
there's no full nature and cause or the actual signed.
Like the citation or the original charging document?
Yes,
Okay.
because
can
I had
provide
requested
that.
all that stuff from you previously.
Okay, I can provide that along with the discovery, and I'll give you another physical copy, and
Okay.
I'll have the videos printed on disc so that you have that as well.
Can you do a flash drive or something? I don't have a disk drive, but okay.
We can do flash drive, yes.
Okay, so Ms. Lamonti, do you need more time to speak with the Office of Public Defender in this case before proceeding further with the Ferretta inquiry?
No.
Let me advise you the potential penalties if you are found guilty of these charges. If you are found guilty by the jury or court for each of the charges, let me take a look here. So the information has charged you with, the state attorney's office has charged you by information with obstructing, resisting an officer without violence, and driving while license suspended or revoked. Count one, the obstructing or resisting arrest without violence is a first-degree misdemeanor. The minimum punishment is a withholding court cost. The maximum punishment is up to a year in the Pinellas County Jail, and up to a year of probation, and up to $1,000 fine on top of the court costs. For the driving while license suspended or revoked charge, it's a second-degree misdemeanor, so the minimum punishment is withholding adjudication and court costs. The maximum, is up to a conviction, as well as the first-degree maximum also includes a conviction. But for the second count here, which is the second degree, the maximum is a conviction, a $500 fine on top of the court costs, up to 6 months probation, and up to 60 days in the Pinellas County Jail. So the maximum you could be facing, doesn't mean that you would get this or not, but this is the maximum potential, is up to 1 year and 6 months of probation, and up to 1 day short of 1 year and 60 days in the Pinellas County Jail. So basically a year and 59 days in the Pinellas County Jail. Do you understand that?
I comprehend.
All right. Do you understand that you may be required to report to probation if convicted? Up to that maximum time we talked about?
I acknowledge.
Okay. You may be required to pay a fine or restitution. You may have a permanent criminal record. Do you understand all that?
I comprehend.
Do you understand that if you're not a United States citizen and if you are found guilty, you could be deported from this country, excluded from entering this country in the future, and denied the opportunity to become a naturalized citizen?
Comprehend.
Do Do you have any questions about the charges or the possible consequences and penalties if you are found guilty, as I've explained them to you? Not about the merits of the charge, just about anything I discussed.
No.
I need to ask you a few more questions about yourself to determine if you are competent to make a knowing and intelligent waiver of counsel. How old are you?
Can I ask real quick for clarification, because I don't waive the right to counsel. You're saying
Well,
to
you
waive
say
the
you
right.
want to represent yourself.
Right, but if I choose, I don't want to waive the right to possibly in the future.
Right. You can always, if you change your mind in the future, you can always have the public defender's office reappointed.
Right, but I
We're talking
also,
about right now, this very moment, you're waiving your right to a counsel.
But-
You wish to represent yourself. We can talk about standby counsel at the end of all this if we get through it, but you are representing yourself if you go through this. That's what you're choosing to do. So let me ask you again. I need to ask you, do you still wish to waive your right to counsel and represent yourself?
At this
for
time.
today? Okay. How old are you?
I'm
That's the easiest question we get all day.
sorry. I'm around 50 years,
Well, how old are you exactly?
around that.
No, how old are you?
I don't know exactly.
What's your birthday?
I don't have a birthday. I have a nativity somewhere
What's your
around.
nativity?
I was born somewhere around 1974.
Okay, so that would make you, what, 51 or 52? Date of birth is listed as 58, August 1st, is that correct?
I have a nativity around that time.
Now, around that time or that time? Did you
That's
come
what my
to
mother
this
told
August
me.
1st, 1974, yes or no?
My mom said it was a full moon around that time, yes.
Okay, so, not there yet, but looks like 51 years old, is that correct?
Roughly, yes.
Roughly or exactly?
Not exactly, because there's not an exact on that.
Why is it
But
not
because
exact?
I'm not 51 yet.
Well, if you're born 1974, oh, I see what you're saying. Okay, so you're 50, that's fair. Okay, so you're 50 years old right now, correct?
Yes.
All right, there you go. Can you read?
Yes.
Can you write?
Yes.
Do you have any difficulty understanding English?
I speak American English. Yes.
Okay. Do you have any difficulty understanding English?
Depends on what kind of English, but yes. I don't have difficulty with
I'll ask the
English.
question again. Do you have any difficulty in understanding English?
I comprehend English, yes.
Do you have any difficulty understanding English, yes or no? If you have difficulty understanding...
I do not
then
have
that's not
difficulty.
okay.
I do not have difficulty understanding English.
Okay, how many years of school have you completed?
I don't know.
Did you graduate high school?
I believe so, yes.
Well, you believe so or you did?
Yes, of course I did.
Well, not of course.
What does that have to do with the
There's plenty of people in
questions?
here who
Yes.
have not
Yeah, yeah.
completed high school at
Okay.
all. What does it have to do is because these are questions to make sure that you have the requisite ability to represent yourself. So
Okay.
if you have no formal schooling at all, then that's one thing. If you do, then that's something that can take into account. So what's your highest level of education?
I went to college.
Okay, did you receive a degree? Did
I-
you graduate from college or no? That doesn't matter, I'm just curious.
Yes.
Okay. Do you have any post-college education as well or no?
No.
All right. Are you currently under the influence of drugs or alcohol?
No.
Have you ever been diagnosed and treated for any mental illness?
No.
Okay.
Nothing.
Do you have any physical problems that would hinder your self-representation in this case, such as a hearing problem, speech impediment, or poor eyesight?
No.
Has anyone told you not to use a lawyer?
No.
Has anyone threatened you in any way to not accept a lawyer appointed on your behalf?
I believe no.
Do you believe no or no?
No.
Do you understand that a lawyer appointed by the court will represent you for free? Which is an application fee, I suppose. But do you understand that?
I comprehend that, yes.
Have you ever represented yourself in a trial beforehand?
No.
Do you have any questions about having a lawyer appointed, continue to appoint, start that again. Do you have any questions about having a lawyer continuing to represent you in this case?
No.
Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges and the possible consequences in the event of a conviction, are you certain that you did not want me to have a lawyer continue to represent you in this case?
What was that last little part?
I'll say the whole thing again. Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges, and the possible consequences in the event of a conviction, are you certain that you do not want me to continue to have a lawyer appointed to represent you?
I have been advised, and yes, I would like to continue without.
Okay. If I do allow you to represent yourself, do you wish to have standby counsel appointed?
Not at this time.
Okay. If I allow you to represent yourself at trial, and if you requested, I could have the Assistant Public Defender act as standby counsel. He or she would be available to you if you have any questions in the course of these proceedings. Just to clarify that point, now that I've said that, would you like to have standby counsel appointed to represent you?
Not at this time.
Appointed as standby counsel.
Not at this time.
Okay. Do you have any additional questions before I make any findings?
No.
Okay. Now, I'm going to make a finding on the record that based upon this specific foreign inquiry, that I'm going to caveat it here, that in the past, Ms. Labonte has not shown the ability to act appropriately in court, manifest appropriate court behavior, has continually spoken over a number of parties in court. Today, she has shown the ability to act appropriately in court and manifest appropriate courtroom behavior. So based upon, for today's purposes, and moving forward, unless proven otherwise, I'm going to find that Ms. Labonte is competent to waive counsel based upon the questions that she's been asked and answered. That her waiver of counsel is knowing and intelligent, and that there are no one has forced her to make this decision, and she has the requisite education, appears to be alert in her responses to the extent that I will allow her to represent herself for right now.
Thank you.
Let's go to the next part here.
And just briefly, Your Honor, I will make all of the documents that we talked about available to you. You can pick them up at the front desk, like where we met last time, and but just give me like 2 to 3 days to get an investigator to have it officially on a flash drive. Okay.
Okay, thank you. Appreciate it.
All right, so a couple of things. I heard Ms. Trey just now state that the Public Defender's Office is going to make the discovery charging document available to you. The next part is any motions that you had filed while being represented by the Office of Public Defender, if you wish to, since they were filed while being represented, they are what's called a nullity. So if you wish to refile anything while you are self-representing yourself, you certainly can.
Okay.
So, and then if you do file any motions, you have to make sure that complying with the rules of criminal procedure, just like anybody else,
Okay.
that the state attorney's office is CC'd for service purposes, maybe done through the e-portal system, which is the preference, I believe. And then with a courtesy copy to myself. Now, I think that there is one thing you did file that I need to address, because it's not substantive, it's procedural. And we need to find out where it is. So, go through a couple of the things that you filed. So, one of which, okay. So, it was filed on, let's say, May 29th. In part, it was emergency verified notice and motion for disqualification and recusal of presiding judge. There was one for me and one for Judge Caminos. Judge Caminos is obviously no longer presiding over this case. I am at the moment. That, since it's a disqualification motion, I will allow you to re-adopt that and not refile it for whatever reason. So, do you wish to adopt that or not adopt that motion while self-represented?
Can you explain that to me?
I cannot comment on it. But procedurally, what I'm asking is, you filed a motion to disqualify while represented. If you wish to have that motion, go forward with that motion and seek disqualification of me, then I'll make a ruling on it.
Okay.
And if you don't, and you wish to withdraw it, then we won't. I'm not commenting on anything other than that's the procedure, because it's not appropriate for me to do so.
Okay,
So are
so,
you adopting that motion, yes or no?
yes,
Okay. So I'm going to grant the motion to disqualify. I will follow up with the written order.
okay,
And
I appreciate
you
that.
will receive a new court date in the mail in front of a different judge.
I appreciate that, thank you very much.
Well, I can't, I haven't trusted.
Appreciate it.
All right, so just make sure that you have your address up to date with the clerk's office, because there's a bond as well, actually, so, make sure that, I'm not sure if you're self-bonded or not, I'm just double check that.
Yes.
Looks like you are. So just make sure that your address is up to date with the clerk's office.
Okay.
So, the court administration will reassign, the case to a separate judge, and, you will receive your next court date in the mail. So there's nothing to be signed for that.
Okay, thank you.
Okay? All right.
Have a great day, thank you.
Deputy Chief Town Hall, for the new president for the afternoon brief.